Today's presenter, Russell Jackman, is a graduate of the McGeorge School of Law, University of Pacific, and was admitted to the State Bar of California in June of 1994. He has been vice chair of the California State Bar's Law Practice Management and Technology Committee and a member since 1996. He works specifically with law offices and attorneys that need to get the most out of their legal technology and creates PowerPoint presentations for opening statements, direct examinations, and closing statements to be used in court, and can work with attorneys directly to filter their documents and images so that they have the most powerful visual presentations possible. He also works with law offices and solo attorneys to upgrade their older systems to new ones, troubleshooting existing setups, and training attorneys and staff on Microsoft programs. He is available for remote access consulting on technology-related issues, so please feel free to contact him at any time.
Hello, my name is Russell Jackman, and this talk that we're going to have today is about sexual harassment, attorneys, and social media. And for those of you that are familiar with the work that I've done for the Center for Continuing Education, I think a lot of you would say, well, I understand he's a technology attorney. I know he's a guy that's worked a lot with computers in the law and computer security. What necessarily does he know about sexual harassment, or what kind of experience does he have with it? Because maybe he's never really dealt with those sort of issues directly because technology went into that. Well, the thing is, one of the things that I have done is that I was general counsel for a major dealership, auto dealership here in California. And I was general counsel there for about 2.5 years. And unfortunately, I was thinking that I'd be doing a lot of contracts. I thought I'd be doing a lot of, negotiating deals and leases and so forth. Really, I did a lot of work on as general counsel was sexual harassment lawsuits within the company. They're just, unfortunately, it's a pervasive problem with people that are working with each other and having, closeness, that lines that don't separate between work and personal life. And so people don't understand that there are, professional levels of how you need to adhere to working at making a workable atmosphere for everyone, in an environment where people feel professional and feel safe, feel that they have the ability to focus on work, not on being sexually harassed. I mean, there's really no other simple way to put a description on it other than just having to say, well, you have these kind of problems that are going on, and they're all very preventable in the sense that none of these things have to happen, yet they continue to happen because people make a lot of poor choices. And social media is an extension. It's a tool. It's just like anything else that humans use to do good things and bad things with. And as social media gains a greater hold in so many things that we do, it also has the ability to be used and abused in situations where we see sexual harassment. So what we're going to try to talk about today is, instead of just purely identifying sexual harassment or talking about the actual prosecution of sexual harassment, which is, we have another lecture about that for the Center for Continuing Education, and it's excellent. So I highly recommend that you check that out. This is really going to talk about the role of attorneys combined with social media, and how social media both causes problems and also helps solve problems for sexual harassment and those kinds of issues, because it's an important thing. The elimination of sexual harassment in the law office and at work in general is something that definitely is a big thing that's been in the news recently and requires addressing. Let's look at sexual harassment by the numbers. One recent study showed that 35% or more than 1 in 3 female lawyers have been sexually harassed at work, and 70% female lawyers reported hearing sexist comments, stories, or jokes at work. The study also found that 77% of female harassment victims and 88% of male victims never reported the incident. So you have almost a 90% rate of men who have been sexually harassed that haven't felt like they can come forward with it. So the anonymity of why 77% and 88% of these things don't get reported is where you have a lot of these problems sort of stemming from. Plus that sort of overwhelming evidence that the perpetrator feels that they will not be prosecuted for any of these situations, and that there's there's a great chance that if they conduct something like this, that they'll get away with it, is a big problem with why it gets perpetuated, because there's this prevailing attitude that, no one's ever going to find out about it. If they do, nothing's going to happen. And so according to the statistics published by the American Bar Association on women in the profession, although almost half of all summer associates in private practice are women, make up only 22% of the partners and 19% of equity partnerships. So you don't really have major number of women that are, you really are looking at 80%, about, high 70s to 80% that are in control of law offices by men, and it's a male dominated situation that is having to be dealt with. So there's certainly an inequitable power structure that has been set up by a lot of law offices. And so again, because it's got such a male-centered concept, plus it has so much anonymity, and there's this sense of there's just the old boys club not representing, not defending, defending their own, and not really, being fair to women or anyone that gets sexually harassed, has been a really big problem. And as we see the cost of harassment, there was a HR blog that had the following statistics, that they said that there were 6,870 complaints lodged with the EEOC in 2015, and that the cost of the average harassment claim in an organization was between $75,000 and $125,000, assuming that claim is settled out of court. And that they said that the amount lost per year by the average Fortune 500 company due to sexual harassment was around 6.7 million. And those are numbers from 5 years ago. They're probably even higher numbers today. So this old boys club and old boys attitude has come back to really haunt the world of, uh, old boy network, uh, inequitable sexual harassment environment that's been coddled for unfortunately too long and has uh, unfortunately created such a negative environment that we really let ourselves. If you notice that the Me Too came into effect more around 2017, so these numbers probably are higher now, and as we go into more of a you know an aware society of these sort of things. Um, this is a situation where it can really, every company, Fortune 500 company, spending over almost $7 million back in 2015, that number, who knows, could be much higher than that. We haven't seen all the statistics come in from that point on forward. If an employer loses a summary judgment, the employer can expect to spend a total of 170,000 to 250,000 to take a case to a jury verdict trial. And um, a lot of times the harassment issues arguably, could be maybe not covered under various types of insurance. So, I'm not sure what claims can be made and what sort of coverage you will get from something like that. I'm not an insurance specialist, but if it isn't covered under insurance, then that's even, more of a threat. And it's, people can be sued not just through the firm itself or through the company, but also personally sued in these suits. And of course, there are criminal uh, uh, charges that could even apply in extreme cases that are get out of control. So um, the money that is involved in something like this is absolutely huge, and it's something that every business really needs to take seriously. Um, uh, uh, there are also other laws too, especially in California, that are coming up, such as uh, the one that's going to make more. It will take away from the rating of people as independent contractors, um, and have them uh, instead of being listed as independent contractors, they'll be listed as employees in California under a variety of different rules. And that change of independent contractors, making them employees, also means that levels of sexual harassment could increase, as well as, people that were what they would be considered casual casual employees that were independent contractors are now considered full-time employees, and therefore subject to greater protection under these kind of laws, regulations. Um, the U.S. saw that in 2018, saw a 50% increase in the sexual harassment lawsuits over the previous year. And then the EEOC stated that it filed 66 harassment lawsuits in the fiscal year of 2018, which 41 contained allegations of sexual harassment. 16, moreover, the agency recovered about 70 million for sexual harassment victims in the fiscal year of 2018, compared to 47 million that it got in 2007. This trend clearly indicates that there is need for more effective anti-harassment policies in the workplace by individual agencies and law firms. So you're seeing nearly a doubling in 2018 from 2017. And it's become so huge of an issue and costing so much that it really needs to be addressed by law offices. They need to be looking and paying attention to what's going on. Attorneys need to be addressing what's going on at their firms and understanding what needs to be done. They need to use all available tools to combat the problems of sexual harassment and being behind the curve on something like this, something that is really costing them a huge amount of money that they're going to regret sooner than later. They, have this situation going on, and certainly in the situation that I recall from my time as a in-house counsel, is that especially with different dealerships, you have different types of cultures going on, that some of them just people were really what you would consider overly friendly, and they were really at this one particular dealership just spending too much time intermixing outside of business and in with business, and they couldn't draw a line between the things that were going on in their personal lives, what was going on at the office. And that then becomes a real problem where relationships go bad. You have people alleging other people cheating on each other, and you have new employees come in and feel that they need to be as personable as the rest of the other employees and go out with them and socialize with them, because it's the only way they'll be able to function at work. If they don't do that and they aren't part of the in crowd, then they'll be excluded, or they'll feel they'll be excluded at work and shunned. And so it's sort of there is this sort of culture that will feed on itself, and social media has a role in all of that. That's where all this is sort of going. I know people will be saying first, well, how does this involve social media? But it does, because when these groups of people are associating together and talking back and forth, they're using social media to either perpetuate the harassment sometimes, or in a more positive view, what we'll talk about is maybe using it as a way to get support and to find ways of dealing with it through social media as well. So it's as I was saying earlier, social media, like anything like we've seen, is a tool and has the ability to be used, but how we use it will do a lot, will say a lot as to whether the costs of harassment continue to spiral out of control, or whether we can get them, back down to a reasonable level. So one of the laws that covers this in the American Bar Association rules is Rule 8.4G. And that is the rules of the model rules of professional conduct that say that it's unprofessional for a lawyer to engage in conduct that the lawyer knows or reasonably should know it's harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status, and conduct related to the practice of law. So what we see from this rule is that it's saying that the lawyer should know or reasonably should know. And that, of course, makes it and puts it into a subjective term that does create challenges. And what is a level of what somebody should reasonably know. And I mean, there are a lot of examples of it, obviously, but that's where the line has to get drawn, because without that, you don't really have it. It's if you just base it on when the lawyer knows it for sure, it's not, the level of proof gets too difficult. So it's important that there is the reasonable standard that's put in there. And then they do, separate out all the different types of harassment that you can have, including gender identity, socioeconomic status, because they want to make sure that that you have all different levels of how you're not supposed to harass or discriminate against somebody. But since the adoption of Rule 8.4G, the jurisdictions have adopted rule analogous to Rule 8.4G. Only 6 jurisdictions, 6 jurisdictions have declined to adopt Rule 8.4G. 19 jurisdictions have no language regarding discrimination. Vermont is the only state that has embraced the recommended language that included conduct in the practice of law. So it's not exactly a rule that's there in every jurisdiction. So it's harder to enforce, especially when you're talking about the challenge that you're talking about the challenges that go on beyond state lines for how social media works. I mean, social media's presence everywhere and across all of the world means that when you have localized jurisdictional rulings on things like ethics and harassment, it is hard to then apply it necessarily to the activities that are going on social media on a national basis and being done with international rule. Social media, obviously, and this is maybe one of the big issues, is it makes it easier to harass. So social media sites offer a number of opportunities for employees to engage in conduct that can give rise to actionable claims. Platforms like Facebook, Twitter, YouTube give employees tools to post sexual comments or pictures to one another's and to cyberbully coworkers. And so that's where I think the greatest danger really comes from, especially people doing what's known in the terms as doxing. That is, they will go and they'll get into an argument with somebody, then they will go look on their personal page, they'll look things up about them on Google, on Yahoo, maybe they're on Yelp or something like that. And then they'll take it a step further. They will call or email the employer of a particular, person, and then threaten the employer saying, this person said this person said that, or this person, harassed me, or this person didn't harass me. It's so easy to make something up. And I know of a situation where a person he had their place of employment emailed and said that if you don't fire this employee within 72 hours, you'll regret having this person working for your company. Now, again, it was veiled, threat was veiled. It was something that specific action wasn't actually said. I don't know if that person was fired from that job or not, because the person left the social media sphere immediately and has not been heard from since. So, it's that kind of. Now, one thing that obviously happens too is that somebody will get rid of their profile, but come back with another profile under another name, just start continuing the harassment all over again. And so it can be sort of like this never-ending hydra that you're fighting, that you get rid of one person, you think they're gone, you block them, and then they come back as somebody else, and you got to block them again. They come back and they try to block again, and they go to the level of, threatening families, threatening uh, employers, that sort of thing, and they take it too darn far. So the popularity of these websites has, once it goes outside of work, does really cross over the line and make people. It's something that obviously a place like Facebook and Twitter and YouTube and other, those companies aren't going to do anything to protect you from when things go outside of their company. The best they can do, if anything, is just disable that person's account, maybe find their IP address, and then make sure that if that IP address tries to log in again and sign up with their service, that it's blocked. But other than that, there isn't much more they can do, and most importantly, there isn't much more that they will do to protect you. And so that's become a bigger and bigger problem. I don't necessarily have an answer to that particular issue. Even though this conduct occurred outside the office or after work hours, the employer may not be relieved of responsibility. If the employer knows or should know that the discriminating conduct is occurring, has the duty to address it through proactive and effective steps. It is getting to the point where, like it or not, if an employee is making a statement that subjects the employer to lost business, to a negative public image, to being the target of negative campaigns, because this person is saying things in a company uniform, associated with a company web email, or on a company website, or for a company's social media account, it will tag that and drag down the employer, the law firm, the attorneys that are associated with it. And so when you have these situations where you're having social media getting out of control, you really do need to see a greater role by the owners of the social media sites to clamp down on it before it gets to that level, and to be able to control it before it gets out of control. Unfortunately, then of course you have overreach and situations where innocent people are accused of this. And I certainly, when I was at the auto dealership, there was a situation where somebody had not done what he was accused of. It was actually pretty obvious. And the investigation, I was involved in the investigation of that, based with the individuals. And when the accuser doesn't want to cooperate in the investigation, the accuser will not make themselves available at any particular point. The accusation's made, then when people try to investigate to follow up and you can't contact that person, and that person makes themselves hard to communicate with, it makes the story harder to believe. And then when you can't find anyone to corroborate it other than someone else who has, a personal beef with the company and has a bias and a reason to lie, but you can't find any uh, uh, persons that are neutral, that have no stake against the company to give an unbiased opinion of the harassment that was alleged to have gone on in the workplace, then it's hard to believe somebody's allegations. But by and large, the attitude is usually that the accuser is right, that you're the assumption that the accuser is right, and that you're trying to prove the other person innocent versus the other way around, that the accuser is considered, I think in the past the accuser was always considered wrong, and usually the old boys network was turning around and saying, okay, you were, uh, 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 they were accusing the accuser and not accusing the accused. And now I think it goes more the other way because of the size of these lawsuits and value of these lawsuits. So is more sexual harassment starting to occur on social media? So what we have been seeing is that social media has become a bigger ground for sexual harassment to occur. Coworkers become Facebook friends or follow each other on Twitter, and they become more personal than professional. Perpetrators of sexual harassment on social media suggest that social platforms feel more private. Many people don't understand that legally harassment that occurs on social media outside the workplace between two co-workers or a supervisor and employee still counts as sexual harassment in the workplace. That's a key element, especially when you see situations where there's a power, where you have a situation of power, employer, employee, or two co-workers, but one has seniority over the other, or a supervisor, or anything where you have an inequitable power relationship. Again, that gets extended into things like text, into Facebook chats and messenger chats and FaceTime and YouTube and other Zoom chats and things like that. Now, one thing that happens is that people don't necessarily go into it thinking that's going to happen, and then it develops that way. And so, it's not necessarily the intention of people who do this to become Facebook friends. This is what's going to happen, but it's something that can happen, and becomes a challenge. So you're seeing sexual harassment has the opportunity. I mean, when people do spend time closer together on social media, it's an extension of human behavior. And so people that aren't well trained and understand where the limits are, what creates a sexual harassment scenario, are going to have that happen on social media the way they would if it was in the office as well. And sometimes that sort of anonymity does cause people to feel like they can say stuff online that they wouldn't say in person. And you'd say, well, this person's not really anonymous. They're a friend on Facebook. They know something about them. They're still like the non-reading of body language, the lack of eye contact, the kind of flippant way some people just type so quickly and don't ever think about what they're typing about, like a certain president the United States and hit send before they review anything. I mean, everything that goes on Facebook, everything that goes on Twitter was something that could have been edited. Nobody forced anyone to hit the send button. But the problem is you have a lot of people doing that, getting themselves in trouble. And the impulse of people and the kind of the necessity, they have to hit send right after they've typed something that they shouldn't have typed, is still something that we see more of rather than less of, especially in this day of the Me Too movement. So we are seeing that now with the politically charged climate that we have, there is a lot more sexual harassment coming to surface. And so when we see the hashtags that are going around like Me Too, like sexism, hashtag says sexism, hashtag sexual harassment, to tag conversations, to tag statements that are made, it has really large repercussions. Bill O'Reilly was ousted from Fox News after having $13 million worth of sexual harassment claims lodged against him. And then Uber is being put under a lot of litigation based on ignoring sexual harassment claims that have been brought against top performers in their organization. So you can see that as sexual harassment uses social media as a tool, so are the people who are fighting sexual harassment use social media as a tool to identify it, to out it, to shine light on it, to make people aware of the issues that are going on, and to, basically eventually find a way to punish those who are guilty of committing harassment. So it's a way, as a tool, it has both edges, and we are seeing people utilize, especially women, using the power of social media to get the word out and to identify and to pursue the ending of sexual harassment situations. And political leaders now see that when they ignore sexual harassment, that there's the repercussions. And when when stuff is ignored, and when somebody makes a big statement about that, where normally these sort of statements got to be swept under the rug by the Old Boys Network, like we were talking about when we first started this talk about, how you really have about an 80% number, high 70s to 80% number of men that are in charge of most law firms. And really that number is pretty much there for a lot of corporate America too, where you have these sort of, I'm not going to listen, to what a woman is going to say about, the old boy network that's here on the board of directors, or the firm partners, or what have you. Well, this is an end around, and say a way of saying, well, you know what, my voice does have the ability to be heard by going to by being able to go and using social media, they can multiply the power of their voices to be able to compete on a level and be heard in a way that they wouldn't have been able to be heard in the past by the male-dominated Old Boys Network. So here's an example of a social media harassment case study, and it's good to use a company that's no longer around so they can't get too upset. But we see that in the YIP Yak social media site, it was University of Mary Washington in Virginia alleged that they were having their rights violated. Their Title IX sex discrimination rights were violated because they weren't protected from online sexual harassment. And they said that the users of the YIP Yak app were making derogatory statements against them in 2014 and 15, and they were also named personally in some of these slurs. You know, it wasn't just the United UMW's Feminist United group, but the actual individual members were called out. And the Fourth Circuit ruled that the University of Washington, Mary Washington, could be sued. The university had sufficient control over the harassment to be liable for the creation of a hostile and abusive school environment, despite the harassment being conducted anonymously on school media. The opinion provides useful suggestions what schools and at some point in time law firms can and should do when confronted with complaints about bullying and harassment. So the after the decision was settled out of court, so it wasn't actually precedents done set by this, but what you do have here is the idea that if it's something that the law office has control over, for instance, its social media account, or anything that has the @ symbol and their firm name after it, those are things that they are that associate themselves with the employees that use that email, that use that social media service, that log onto that page or that wall, or that use that Twitter account. And so the rules have to be really clear that this is something that not only are they not going to use, but if they are associated with this firm, that if they're going to use social media in any capacity, and that they're associated, that they don't want to be, to have any kind of negative association with the social media, their social media, and with the firm. And so it's important for firms to start looking into investigating their individual employees, saying, look, as long as you're working for this firm, sometimes it's better if you're at a position, a really important position at a firm, for you to maybe really watch what you post, even on your personal social media account. Because if you wind up having your social media account linked with that of the firm, or you're talking about things that then you don't disassociate yourself clearly from what the firm is thinking, the firm can get pulled in like the University of Mary Washington, and be said that you are creating a hostile and abusive work environment based on the fact that you're having an argument on social media with somebody else that's in the same kind of firm or company as you, and that person will feel, well, because I've been harassed on social media, the next time I show up at work, I'm going to get harassed too. And then that will draw in the company to liability, like we're talking about. So it's the YIP Yak app, which was created in 2013, was really and it was supposed to be something that was helping colleges communicate to each other, became a hotbed of cyberbullying, hate speech, and then even bomb threat came in via the app, and so it had to close down in 2017. It got to be a situation that was brought in out of its control, and so we can see that, unfortunately there is a lot of scary hate out there. There is a lot of ability for people to take something that was well intentioned and to just be a simple communication system between folks in the universities and college campuses. But like any tool, it can be corrupted and made into something that can create harm. So, but ultimately, what courts are looking at is to see how much control you have over those particular posts and the particular emails and so forth. If they do, run from a company server, if they are based on a company website or firm website, unfortunately, they're going to look to the biggest actor in something like this instead of going against the smaller person, which they may do in a civil suit, but they're going to try to stop it at the source, and you don't want your law firm to be part of that. So what can be done? Okay. So, well, the first element in a situation like this is to always document what you have. And that is actually one of maybe the better parts of this whole social media thing, is that it all is documented somewhere. None of this stuff happens in a vacuum. It is not like when people say things in a hallway where it's just the two of them. Usually with social media, you'll have the ability to record it, you have the ability to save it, you have the ability to track it. The services themselves can be perhaps subpoenaed and produce the records of it. They have backups of it. So it's kind of it's easier than other situations to provide proof of social media sexual harassment. It is really important that we saw the numbers earlier of how many times things like this are not reported. When there isn't a report that's been made of sexual harassment, that there's no paper trail that's created. And with no paper trail that's created, unfortunately, you don't have a basis on which to punish someone. And there's usually this attitude that, well, we don't want to do anything to a first-time offender. But if we knew that it was the 5th or 6th or 8th or 20th time somebody had offended this, and this is an action, a repeat problem that continues to go on, that nothing gets done, that's when you have liability starting to reach in from the court and saying, well, you should have known, a reasonable firm would have known under these circumstances that this person was a problem, that this person was using social media. Anybody could have just gone and seen these posts. They had just gone on to Facebook and looked at what this person was typing. This person was saying these things on Twitter, and everyone had a chance to do this. So to find this out. So if there isn't the kind of reporting that's done and people stay silent about it, it perpetuates itself. And as I said, the attitude becomes, well, sure, I can do this because I know I'm not going to get caught. And that just builds on itself and it just gets much worse. It's important to try to institute an anonymous system in law firms so that people feel they can report without feeling that they're going to be feeling any retribution against it. Because even when, let's say, a law firm will fire somebody because of sexual harassment, a lot of times that person will, because they aren't all that balanced in the first place to commit the sexual harassment to begin with, they'll do other things such as stalk or try to sabotage that person, and get revenge on them. And so finding a way to make the system anonymous, to make it so that it is something that coming more from the firm or the company than it is from a particular person goes a long way to helping the people who feel they can. You don't have to. I'm not worried about the people who are being accused of harassment so much, but of the people who are reporting. If they feel that they're going to be put in the spotlight and grilled and made feel very unpleasant and accused of things, when the truth is they're trying to get help, that's not going to be conducive to an environment where anyone is going to report. So you do need some kind of an anonymous system. The next thing you can do, as I pointed out, is to block someone. That's good and it's bad. I mean, some people, when you block them, they'll get the message and they'll go away. And others will go and, like a serpent, the hydra, you cut one head off and another head pops back up. And then you cut that head off and another one comes back up. They will keep attacking from other email addresses and other IDs that they'll keep logging in as fake IDs. And as I said, the only real way to stop it, if you can stop it, is to contact the service itself, have them trace down the IP address, the source IP address of these emails, block the actual IP itself from being able to whitelist the service. It's allowing them to send these emails or to harass through these particular social media services. And then there's obviously going one step further and getting an actual a restraining order against that person. And that's where you go outside of the internet to get assistance. And that obviously, involves having a lawsuit of some measure. Or as I said, getting a restraining order against the other party, a civil restraining order where you're saying that, the sexual harassment is coming from social media, that they need to not make any disparaging remarks to you on social media, that they're refrain from communicating with you by email as well as other sources, and if they violate that, then they are in violation of court order and they could be arrested, which would go a long way towards probably making the person that was involved in creating those harassing situations probably stop from doing it. Because if you have, I think that a lot of these people, again, do what they do based on the idea that they can do it anonymously, that there's no repercussions for it, that gives them a feeling of power, and that they have the ability to scare somebody doing what they want based on the power that they have combined with anonymity. But if their name is involved in a lawsuit, they see a restraining order is handed to them, they have to show up in court, that sort of power situation goes the other way. And you certainly don't have the same kind of feeling of superiority when they have to deal with that sort of a restraining order. And you can also look to see if there are elements of fraud that are being done, especially when people are signing in as different names or different accounts, so that you can maybe see to get them banned permanently from these services. There's certainly a claim as to being placed under emotional distress in a situation like this, and having your rights violated in a civil sense by having to endure this harassment, being put under the kind of stress that is easily documented. You can at least show the outrageous conduct by showing the screen caps or the screen captures or the copies of the texts that were sent to you or the posts that were made. And the usually in most circumstances they're unreasonable enough that they give a lot of impetus to the claim of emotional distress. And then there's always the fact that there may be employment code violations that occur from a situation like this. So, especially when we're talking about things like supervisors to the other employees, or ones that are, partners to associates, or perhaps summer associates, or secretaries or paralegals that are under the supervision of partners or other associates. Those kinds of relationships where you have employers with the power over the employees. And again, we're in a whole new era now, or we may be entering a new era now, where many more independent contractors are considered employees. That will change the dynamics and hopefully lead to greater awareness across the board that this sort of behavior just has to stop. I mean, an increase in just a couple of years from $40 million worth of lawsuits to $70 million worth of lawsuits. And again, I wouldn't be surprised if when the numbers finally come out for, the 2019 or 2020, that we wouldn't be in like the $100 million lawsuit range. Although right now with COVID-19, a lot of the offices are closed. So we'll have to just see if the element of social media and sexual harassment becomes an increased level of concern in lawsuits as time moves forward in this current environment, or whether sexual harassment may go down if people are not seeing everybody in person. So it's going to be interesting to see how those rates and those numbers change based on the change in the office environment we currently have. Finally, what can be done? Employee training. That's probably the most important thing out of this whole thing, out of all of this, is if people understand the limits, people understand how they're not supposed to act, how they are supposed to behave themselves. They understand that it extends outside of just where they're at in the office, where they're at in court, where they're at anywhere, that they owe this sort of level of conduct, and to avoid having situations where you have sexual harassment be a problem, that's going to go a long way towards solving these issues and not having the $70 million worth of lawsuits and so forth. It will lower tensions with employees. It will lower tensions between coworkers. It will raise the level of trust in the workplace, lead to a more conducive work environment. And so social media has its positives. It has its negatives because people can use it as a tool to bully, to sexual harass, the way they can use anything to do that. But to try to look to the positives of social media and to see what law firms can do to offer support groups, to be able to be there for their employees is an important way to get things to be better. And so can social media help? Yes. You can use it for discussion. You can do it for the support groups and to provide information on how to get help. We've seen that it creates awareness, that people are understanding what can be done for fighting back by things like the Me Too movement and so forth. That it gives people some sense of control. As I said, they can get a message out that normally was ignored or squashed by those that were in control. And does it need to be regulated is a good question. I talked about that in another one of my discussions, and there's pros and cons to that. I don't necessarily have the answers here, but knowing that there's a way of at least self-regulating, that by educating and training, that maybe the regulation doesn't have to happen because some people can control themselves without needing the government to do it and without having the sites themselves have to do it. That's really worth discussing, especially with whatever firm you're with. So the conclusion is that sexual harassment is a big deal. Attorneys have a role in reducing sexual harassment. Social media can both harm and help deal with sexual harassment. An attorney should use the positive tools and techniques, including the responsible use of social media, to help deal with sexual harassment issues. My name is Russell Jackman. If you have any questions, please contact me at the above information, and I really appreciate you listening to the talk today. Thank you very much.